Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers. If you're tuning into us in Canada and specifically in British Columbia, Alberta, or Ontario, we are able to assist with really any employment or disability insurance issues that you are having. If you are somewhere else in Canada or you're listening across the global, stay tuned in. We can provide some general information as well. This is an opportunity for those of you tuning in to go ahead and post your questions, whatever platform you're viewing this on. Go ahead and post your question. It could be confidential. You don't have to provide your name. You don't have to provide any information, who your employer is, any specifics whatsoever. Ask a general question. You are speaking with an employment lawyer here, and maybe we can't resolve your situation perfectly over the course of a live stream, but we can definitely get you on the road to resolving your workplace issues, providing some general comments, some general information, and general advice, and again, get you moving in that direction of solving your workplace problems. Certainly, I always start off the segment by providing our contact information. If you are dealing with a difficult situation at work and you are losing sleep over it and you're stressed about it, and it might be something like maybe your boss is mistreating you, maybe you are having a dispute with a colleague, maybe your employer is asking you to change your employment in some way. They're asking you to accept a demotion or a pay change or maybe a schedule change. If you've been laid off from your employment, if you've been let go from your job, these are all situations in which you require urgent advice where you need to speak with an employment lawyer as soon as possible. You have rights as an employee in those kinds of situations. It's imperative that you know the way the law works in those circumstances, because of course, if you don't know the way the law works, then the law cannot help you. As a starting point, please go ahead and visit our website. Employmentlawyer.ca is the website, employmentlawyer.ca. Go ahead and visit our website. Of course, we've got all of our contact information there. We've got all of our various offices and lawyers and paralegals in those various offices. But we've also, perhaps just as importantly, we've got a ton of material on our website, whether it's blog posts, whether it's employment law, kind of 101 essentials, describing certain situations, explaining the way the law works when it comes to terminations and severance or constructive dismissals, as we call them. And of course, we've got lots of video clips as well from interviews we've done with the media over years and years and years now. Go ahead and visit our website. That's the place to start. And you could do some very brief research on your situation. And of course, get in touch with us. Speaking of getting in touch, of course, feel free to go ahead and send us an email. There is absolutely no cost whatsoever in sending us an email. The email address is help@employmentlawyer.ca. You see it on the screen right now. You are contacting, when you send us an email at help@employmentlawyer.ca, you are contacting our intake team who are specialized in triaging and assessing these kinds of situations and putting you in touch with an employment lawyer or with a paralegal. Again, all of us specializing in employment law or even disability insurance law. If you're dealing with a disability insurance situation, go ahead and send us an email. Give us a brief description of the situation that you're dealing with. Don't send us a 10-page long email. Try and keep it as brief and succinct as possible. And I guarantee you, we will contact you in response. Do not be shy to reach out. Oftentimes, people might think that their situation maybe is still developing and they'll only reach out once something more dramatic or drastic happens. And while there's some degree of logic to that, in reality, if you're already dealing with a difficult situation at work, and let's say you're being criticized for your performance by your boss, or you've been temporarily laid off, maybe you've been suspended from your employment due to an investigation that is undergoing. These are all situations where it would benefit you to receive advice immediately from an employment lawyer. We specialize in coaching employees through these kinds of difficult situations. And there are certainly things that you should and also then shouldn't be doing when it comes to dealing with your employer, dealing with your boss, and the way in which you might respond, for example, to a temporary layoff or even to a termination for that matter. Speaking of terminations, and let's get us talking employment law here and get us kind of warmed up. Again, this is a live Q&A. This is a live stream. If you're tuning in right now and you're wondering, what's going on here, go ahead and post your question right now. If you're dealing with a situation at work, if you've been let go from your job, or you're dealing with a difficult boss, you're dealing with changes at work, do not be shy, do not be bashful. Go ahead and post that question right now. I promise I will get to your question and answer it appropriately before the end of the segment to get us thinking employment law and thinking of the various issues that come up in the world of employment law. Wanted to talk about a matter that is in the news right as of this morning. It's actually something that we posted about on our website, employmentlawyer.ca, and we're starting to receive some news and information through the grapevine. A number of individuals have contacted us, former employees now of Rogers Communication. Rogers, of course, is a major telecommunications company in Canada, and it seems as though they are going through a round of layoffs right now, and a number of people, probably several dozens, have been let go from Rogers. I wanted to talk a little bit about terminations, about severance. These are obviously very difficult, very stressful times in anybody's career, certainly in anybody's lives, and run through some of the basics when it comes to termination. So if you or a friend or a family member or anyone, and whether it's Rogers Communications, and again, I bring them up only because we've received news from employees and former employees now of a round of layoffs from Rogers. But whatever the company is, and it could be small, it could be a small family business, it could be a medium-sized business, it could be a large international corporation. The rules are the same when it comes to severance. And there are some basic things, both practically speaking and legally speaking, that you as an employee should be doing when you're dealing with the termination. And again, keep all of this in mind, whether it's for yourself or a family member or a friend. First things first, everyone, when we're talking about a termination, the process is that you are going to be sat down by your employer, whether that's an HR individual, maybe it's a manager, maybe it's a director or a VP or somebody at the executive level. You are sat down for a meeting. That meeting could be virtual, it could be in person. Sometimes it's over the phone, although it's not particularly professional. You are sat down for that meeting and you are being told your services are no longer required. Here is a document confirming that you are being let go from your employment. Maybe you're being let go immediately on that day, right? Maybe you've been given some sort of notice, and maybe it's a few weeks, maybe it's a few months, and you're being given advance notice that your employment is going to be terminating at some point in the near future. Whatever that is, you are going to be provided with a document. And at the end of that document, maybe it's a couple of documents, there is going to be a signature line accepting some sort of severance offer. At least most often, that's the way it works. First piece of advice, do not sign anything on the spot without speaking with an employment lawyer. You might see a big number on that piece of paper. You might think right off the bat that that is a reasonable severance offer. Think again. Oftentimes, almost always, I would say, what an employer offers you initially as a severance package is going to be far less than what your employer actually owes you. What the employer doing here is not illegal per se. They are looking for good value. They are looking to save money on their end by offering you effectively kind of the minimums or the bare bones of what a reasonable offer might look like. Whereas the way the law works, the way severance works, again, I'm talking specifically here in Ontario, Alberta, and British Columbia, is that severance is going to be based on an employee's age, position, and years of service. It's not going to be a couple of weeks or even potentially a couple of months, particularly if you're a longer service employee. Severance could be as much as 2 years of pay, not 2 months, not 1 year, 2 years of pay is, generally speaking, the maximum severance entitlement that an employee is going to be owed. And so that number that you see on a termination letter and a severance offer, again, it might appear attractive at first, but your severance entitlements are likely much more significant than that initial offer. You won't know whether it is or isn't a reasonable offer without speaking with an employment lawyer first. So, rule number one, and the golden rule by far, is do not sign any kind of severance offer on the spot. Make sure you speak with an employment lawyer first. Go ahead and give us a call, send us an email, however you want to contact us. Make sure you speak with someone first before accepting or declining a severance offer. The second piece of advice I would suggest to you, and this is another website that we often refer people to, is pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca is another one of our websites. You see the address on the screen right now, where you can go to answer questions such as, how much severance am I owed? Is what my employer doing legal or not legal? It's an initial kind of a general tool that you can use to get a sense of what your rights and entitlements would be, particularly when it comes to severance. The Pocket Employment Lawyer has a severance pay calculator built within it. It's the same severance pay calculator that we have been suggesting and using for many, many years now. Go ahead and input your age, input your years of service, input your position within the company. Again, your approximate position. Are you a manager? Are you a senior executive or upper management? Are you a technical employee or a laborer? Input your general position there, and out will come a number, and it will give you, again, a good estimate. It's not a perfect assessment per se, but it is a very good estimate of what your severance entitlements will be. And again, it'll give you a sense of what you should be receiving versus what the company has offered you. Don't be shy to use that tool. It is completely free. It is completely anonymous. We don't ask anything of you to use that tool. We don't even ask for an email address for that matter. Of course, if you want to insert your contact information through the Pocket Employment Lawyer, you can. And again, someone will reach out to you when it comes to those circumstances. So again, I wanted to talk about this latest round of layoffs from Rogers Communication to touch on some of the very basics of severance and at least the initial steps in terms of what you should and shouldn't be doing when it comes to dealing with termination of employment. Again, emotions are high. It's a stressful situation. What you don't want to do is sign off on a severance offer blindly. Maybe your employer might even pressure you to. Maybe you might feel compelled to sign on the spot or to sign by a certain deadline without receiving employment law advice. And I'll keep it simple. Don't do it. Even if there's a deadline involved, do not sign off on a severance offer without speaking to an employment lawyer first. These deadlines don't mean anything. They're just another way for an employer to pressure you, to force you into signing. Ultimately, an employee has up to 2 years to pursue their severance entitlements post-termination. Of course, you don't want to wait that long. You want to get on this right away. But I say that to say, don't be pressured by deadlines that employers give you when it comes to severance offers. Whatever the scenario is, whatever pressure you might be feeling, the priority is to make sure you get advice from a good employment lawyer that knows what they're doing, that has experience in those circumstances. And certainly, we specialize in resolving severance claims in those kinds of disputes. If you are an employee, now former employee, unfortunately, of Rogers, and you're dealing with a termination and you're looking at a severance offer, please go ahead and give us a call or send us an email at help@employmentlawyer.ca. But really, whoever your employer is, whatever kind of situation you're dealing with, if you're dealing with a termination at work, maybe you've been let go from your job and it's been alleged that you've done something terribly wrong. Maybe the company is citing misconduct or poor performance as a reason for termination. Maybe they haven't even offered you severance because of those allegations. Again, that's not a situation where you just blindly want to walk away from and think that the employer is right. It's actually very difficult, if not impossible, to terminate an employee without severance, particularly when it comes to performance issues. And so if you're dealing with a for-cause termination and you haven't been offered severance at all the more reason really to speak with an employment lawyer. Make sure that your rights are protected and that your rights are enforced. And that's exactly what we do at Samfiru Tumarkin. We help people resolve exactly those kinds of situations. All right, just circling back to the questions here, folks. We have a good number of questions lined up. Thank you all so much for posting. If you are just tuning in, very quickly, this is a live employment law and disability insurance Q&A, question and answer session. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin LLP. If you are dealing with a situation at work, or maybe you're just curious about how the law works when it comes to a particular situation, maybe you've got a question about your pension, maybe you've got a question about resigning your employment kind of in response to pressure you're feeling from the company. Really, whatever your circumstances are, now is the opportunity to get some guidance, get some information from the source, from an employment lawyer. Do not be shy. Keep your question general. Don't provide any confidential information, of course. And I promise I'll get to your question before the end of the segment. We've got about 13 or 14 minutes left here. So without further ado, let's get to the question. First question is from Sizzle on YouTube, I believe. I've been working as a translator for 6 years, doing this as a freelancer, but I'm looking to take an in-house position. The positions I've interviewed for have all stated they have non-compete clauses that would prohibit me from working with any of their clients for 2 years. If I resume freelance work, would this be considered a breach of contract and cause me problems? This type of work often sees overlap of clients between companies and translators. Sizzle, what a great question. We are talking about non-competition provisions. What a non-competition provision is exactly what you think it is. It is basically a provision in a contract that says if your relationship with the company ends, if your employment ends with the company, and by the way, that could either be a termination from the company, where the company decides to let you go, or it could be a resignation. It might work both ways. And in those circumstances, you may not be allowed to compete with that company, the company that let you go or that you resigned from, for a certain period of time. Sizzle, I can tell you something pretty much right off the bat. And this is specific, again, I will be specific to the province in Canada that I practice law in, and that is Ontario. I can tell you, generally speaking, that 2-year non-competition clauses are very, very often found to be unenforceable. 2 years is too long a period of time to bar someone from earning a living in their profession. And so if you are being offered a non-competition clause that bars you from competing for 2 years, there is a decent chance that that provision in and of itself would be found to be unenforceable. I will add on top of that, by the way, and that is what we call, based on the case law, what's also referred to as common law. So this is judge-made law. I will also add that in Ontario, Sizzle, and again, I'm assuming you're in Ontario here, you may not be. In Ontario, our provincial legislator has actually barred non-competition provisions from employment contracts. And there is one exception. That exception is for executive level employees. If you are a translator, that is obviously not an executive level position, Sizzle. So if you're in Ontario and your employer is putting a non-competition clause into your employment agreement, guess what? It's effectively illegal. You cannot put non-competition provisions into employment contracts in Ontario, really as of, I think it might have been 2021. So a few years ago now, maybe 22, at least a couple of years ago now, that non-competition provisions have effectively been banned for all employees, save and except for executive level employees. So if you are not in Ontario, Sizzle, I'd suggest you reach out to us off air. Give us a call at the office. Send us an email at help@employmentlawyer.ca. If you're in Alberta or in British Columbia, the law may be different. And so I'd suggest that you speak with one of our lawyers in those provinces. All right, next up is Majoran. Majoran asks, I worked 3 days of training and then they said they didn't have enough hours or that they won't move forward with me. They didn't provide proper reasoning for dismissal, didn't pay me for the 3 days that I was supposed to be paid for. Instead, they said my contract states I must successfully complete 80 hours of work with them to be paid. Is this a scam? Shouldn't they pay me? Majoran, it is absolutely a scam. There is no such thing, and again, I'm referring here, guys, to Canadian law and Ontario law specifically. There is no such thing as a trial period when it comes to employment. If you worked 3 days, and whether they called that training or whatever they might have called it, you are owed 3 days of pay, plain and simple. And so it is a scam. This employer is trying to get away with not paying you, Marjoran. And so what I would suggest is if they don't pay you, I would say for things, so this is an unpaid wages issue, right? Clearly, you worked 3 days and you were not paid for the time that you put in. For things like unpaid wages, for things like overtime pay or vacation pay, I would suggest going to the Ministry of Labor in Ontario, filing a claim with the Ministry of Labor in those kinds of situations. Again, unpaid wages, overtime pay, vacation pay, things of that nature. Go to the Ministry of Labor. That's not an issue at all. They can typically help with those kinds of situations. However, and a big however here, a big disclaimer, an asterisk, if you are dealing with the severance issue, or if you're dealing with changes to your employment, again, let's say your employer is cutting your hours or cutting your pay or putting you on temporary layoff, or again, if they've let you go and offered you severance, or maybe they haven't offered you severance, do yourself a favor. Do not go to the Ministry of Labor. The Ministry of Labor cannot help you when it comes to your full severance entitlements. They can only help when it comes to minimum severance entitlements. And again, things like overtime or vacation pay or unpaid wages. Do not go to the Ministry of Labor for a severance claim. It is the wrong move. You have to go to an employment lawyer when it comes to severance, when it comes to temporary layoffs, when it comes to things like changes to your employment or terminations for cause. Don't make the mistake of going to the Ministry of Labor. But Marjoan, I would suggest the Ministry of Labor in your case, because we are talking about unpaid wages. 3 days of pay is not insignificant. I'm sure it's several $100s at least. Don't let that employer get away without paying you. They have to pay for time that you've put in for work, even if it was training. Speaking of temporary layoffs, next up on YouTube, World Boss asks, is temporary layoff legal in Ontario? And it's an excellent question. It's a question we get a lot, and I'm happy to set the record straight on the subject matter. Temporary layoffs, typically speaking, are not legal in Ontario. And what I mean by that is they are only legal in very specific situations. Oftentimes, they can be considered, temporary layoffs can be considered a breach of contract. Now, what do I mean by that? In situations where, for example, you are a seasonal employee, you're a construction employee, for example, and you know that you're going to work April to November, and then you're going to be laid off from November to March during the winter months, and that's kind of the ebb and flow of your employment. That's a temporary layoff, obviously. Listen, in a situation like that, temporary layoffs are going to be legal. They're an implied term of your employment. It's simply the way that kind of business goes. As another example, if you look at your employment contract with your employer, and there is a provision in your employment contract that allows the employer to temporarily lay you off. In other words, it's written in black and white in your contract that your employer is allowed to put you on layoff temporarily. Well, guess what? Whether you spotted that provision at the time that you signed it or not, it's in your contract. You signed the contract. In those situations, your employer can temporarily lay you off, World Boss. Now, those situations I would say are relatively rare. For most employees, layoffs are not a routine part of their employment, right? So you're not working seasonally for the most part. And secondly, most employment contracts don't have temporary layoff language in them. Most of them are completely silent about temporary layoffs. And in those situations, robots, where again, it's not an implied term of your employment, right? It's not part of the regular ebb and flow of your employment. And secondly, it's not in your contract. Temporary layoffs are not legal. I'm talking specifically in Ontario here, since you asked. They are a breach of contract. If it's not in your contract, and if you haven't been laid off before and your employer lays you off, your best bet by far is to treat that temporary layoff as a permanent termination. Obtain your severance entitlements. Again, keep in mind, severance is based on your age, position, and years of service. It's going to be significant. It's not going to be just a couple of weeks of pay. It's going to be lots. Right? Treat that as a permanent termination. Get your severance and get moving on to new employment. You don't want to give your employer the right to temporarily lay you off. Because if you accept it the first time, right? Let's say you're laid off temporarily and you're thinking, well, I hope it's just a few weeks, right? They call me back to work and then my life could go on, as usual. Well, if you accept that and your employer temporarily lays you off once, they can then do it a second time, a third time, a fourth time. And that second, third, and fourth time, you can't take issue then. You can only take issue the first time that it happens, because once you've accepted it once, it then becomes an implied term of your employment. So if you've been temporarily laid off, don't just assume that it's legal. Make sure you look at your employment contract. Make sure you speak with an employment lawyer. We speak to people every single day that have been temporarily laid off from their employment. Every situation is unique. Oftentimes, the best course of action is to simply engage the company in a severance negotiation. By the way, those negotiations aren't particularly difficult oftentimes. Severance is not a complicated matter, but that would be your best bet by far. All right, for the last few minutes here, I will get to the rest of the questions. We'll have to do it a little bit more rapid fire. Cindy is up next on YouTube. Cindy asks, do you get severance if off on medical leave and end up not being able to come back? I've worked for 17 years full time. How is it calculated? Thank you. Cindy, great question. A question we do get often enough. In Ontario, again, specifically. And so, Cindy, if you're in Ontario, this applies to you. If you're not in Ontario, give us a call at the office. Happy to explain the way it works in whichever province you're in. In Ontario specifically, if you are permanently disabled and you are not able to return back to work because of a medical issue, yes, you are owed severance. It is not the same calculation of severance, however, that an ordinary employee who is being let go is owed. Again, severance being based on an employee's age, position, and years of service. Your calculation of severance, Cindy, is going to be a little different, but you are owed severance in a situation like that. It's what we call frustration of contract in Ontario. And it simply means that you are unable to continue your employment because of a medical issue. Severance is owing. It's going to be based, Cindy, on whatever your last earnings or income was prior to your medical leave. So if you're working full time before your medical leave, your severance entitlements are going to be based on that full time employment. It is another situation, I will add, that does require some consideration, that does require some advice. Sometimes, maybe a little more than sometimes, an employer will not be willing to pay severance in those kinds of situations. They'll say, oh, you're not owed it, or, oh, we'd like you to resign. They might also say, well, maybe there's still a chance that you might come back to work, so we don't want to pay you severance now. Employers will sometimes try and get away without paying severance to employees that are medically unable to continue working. And so be very careful with a situation like that. Cindy, if your employer is either not willing to engage with you or giving you a hard time, you should be reaching out to us right away. If they've made you a severance offer, reach out to us. Let's make sure we have a chat about whether that severance offer is the right one or not. Dean is up next. Dean asks, are volunteer firefighters, which is a paid position for sure, are they eligible for severance if let go without cause? Because the income is different from year to year. How is it calculated? Dean, if I understand correctly, volunteer firefighters may very well be unionized. And listen, if you are unionized, then your severance entitlements are going to be governed by your collective agreement. So you've got to speak with your union representative to figure out what kind of severance you're going to be owed. If it's not a unionized position, and I've certainly spoken to plenty of volunteer firefighters in the past, and I can't recall exactly whether all of them are unionized or not. I know some are for sure. If it's not a unionized position, Dean, then I fully expect you would be owed severance as any other employee would be. Again, the point here is there's a distinction between unionized and non-unionized employees when it comes to their severance entitlements. As a non-unionized employee, Dean, your severance would be based on your age, position, and years of service. Same analysis as any other non-unionized employee. If the income is different year to year, the most likely way that your severance will be calculated is that perhaps an average of the past 2 or 3 years would be most appropriate. The alternative would be trying to project into the future and see how much you would have earned over the course of your severance period. So if, for example, you're owed 12 months of severance, theoretically the question would be, well, how much would I have earned over the course of the next 12 months? And that's what your severance entitlements are going to be. It can work either way. Either you take an average of the past couple of years, or you try and project into the future as to what you would have earned over the course of the rest of the severance period. I will leave it at that, folks. We are unfortunately out of time. If I didn't get to your question today, my apologies. Good news is we've got another live Q&A coming up tomorrow with Lior Samfiru. Go ahead and tune in there. And until then, and until next time, everyone, have yourselves a great rest of the day and great rest of the week. Excellent questions today. Happy I was able to help, even if it was just a little bit.